If you possess a semi-automatic firearm and reside in the United States, you absolutely must pay careful attention to what lies ahead in 2026. Numerous states are actively modifying their firearm regulations in ways that place law-abiding gun owners in serious jeopardy of felony prosecution. In several of these jurisdictions, penalties climb as high as 10 years of incarceration, plus thousands of dollars in monetary penalties. Not for criminal misuse, not for violent acts, but merely for possession, incomplete documentation, or overlooking a critical deadline that nobody properly alerted you about. Many individuals currently operate under the belief that they're fully shielded because they acquired their firearms through completely legal channels years prior. That very assumption is precisely what leaves people vulnerable and dangerously unprepared for what's coming. Multiple states are systematically narrowing definitions, broadening enforcement scope, and eliminating long-standing safeguards that gun owners have depended upon for generations. Throughout this comprehensive presentation, I will guide you through the specific jurisdictions where these dangers strike with greatest force. I will clarify precisely what is shifting, when these changes officially activate, and what immediate steps you must take to remain safely within legal boundaries. This compilation grows progressively more severe as we advance through it. Each jurisdiction introduces additional complexity that most individuals assume doesn't concern them until it suddenly and catastrophically does. By the time we arrive at the final entry, the threat isn't apparent through obvious prohibitions or media coverage. It manifests through subtle regulations, outdated guidance, and deeply held beliefs that gun owners have trusted for many years. And that is precisely where individuals find themselves most dangerously trapped. Let us proceed immediately. Disclaimer: I'm not an attorney, and this isn't legal counsel. Firearm statutes shift quickly and vary by zip code. Always consult a licensed lawyer and your local ordinances before acting. Section 9. Colorado. Colorado, fresh acquisition obstacles that subtly transform everything about buying. Colorado isn't implementing an outright prohibition on semi-automatic firearms, and that is precisely why numerous individuals remain dangerously inattentive. Superficially, nothing appears dramatically altered. No seizure headlines, no abrupt forbiddance making news. However, commencing August 1st, 2026, the acquisition procedure transforms in ways that catch numerous gun owners completely unprepared, particularly those presuming Colorado continues operating exactly as it always has before. Here is the absolutely critical element you must fully grasp. If you already possessed your firearms prior to that specific date, authorities aren't compelling you to relinquish them. No registration mandate currently exists for your current inventory, and no fresh possession restrictions appear as frequently seen elsewhere. That is the portion people hear, then unfortunately cease listening to everything else. What transforms is absolutely everything regarding acquisitions after August 1st. Any fresh purchase of a semi-automatic firearm featuring a detachable magazine now demands a state eligibility credential, and that credential isn't automatically granted to anyone. Before you may even submit your petition, you must successfully finish a state-sanctioned safety program. That program incorporates mandatory live ammunition instruction, comprehensive safekeeping education, and thorough legal awareness training. It consumes considerable time, it requires payment of fees, and it definitely isn't voluntary. Following successful completion, you must still clear an additional background investigation merely to obtain the credential itself. The credential lapses every 5 years, meaning this entire procedure must be repeated. And even once secured, you aren't finished. You still must undergo standard federal background screening at the firearm retailer. You still must navigate Colorado's obligatory waiting interval. What previously constituted a straightforward purchase can now extend across multiple weeks or even longer. Transfers transform as well under these rules. After August 1st, every private firearm transfer must route through a properly licensed dealer, whether selling to an acquaintance, presenting to an adult relative, or any other transaction. All of it now demands proper documentation and background verification. verification. Miss that requirement and the initial violation constitutes a misdemeanor. Repeat the offense and it immediately escalates to felony classification with serious consequences. So here is what this truly signifies for owners. Colorado didn't technically prohibit anything. They simply decelerated the entire system, inserted multiple bureaucratic layers, and elevated risk for individuals assuming previous regulations remain applicable to current purchases. If you intend to purchase going forward, timing proves absolutely crucial. And if you currently own firearms, documenting precisely what you possess and exactly when you obtained it matters more than most currently recognize. Section 8. Washington. Washington Safekeeping Regulations Accountability and Routine Daily Legal Exposure. Washington isn't issuing dramatic proclamations regarding prohibitions, and that explains why numerous gun owners don't currently experience any alarm. On official documentation, it merely resembles minor supplementary requirements being added. In actual practice, those requirements fundamentally alter how ownership functions daily, and they introduce significant risks most individuals never anticipate or plan for. Commencing January 1, 2026, Washington intensifies its safekeeping regulations for all semi-automatic firearms. When your firearm isn't under your immediate personal supervision, it must be secured with an appropriate locking mechanism or stored within a proper safe. That portion sounds relatively straightforward. The genuine difficulty emerges when complications unfortunately arise. If a firearm disappears because authorities determine it wasn't properly secured and that firearm is subsequently employed in criminal activity, the owner faces actual criminal prosecution, not merely civil liability. Criminal prosecution with real penalties. Even if you were never present at the scene, even if the theft wasn't your personal responsibility, this transfers legal accountability in ways many aren't prepared to accept or handle. Ownership now carries serious legal vulnerability directly connected to another person's subsequent criminal conduct. A burglary occurring, a defective lock failing, a storage decision authorities later judge insufficient after the fact. Those scenarios can rapidly escalate into genuine legal complications and charges. Acquiring a semi-automatic rifle also transforms significantly. Washington now mandates completion of a state-sanctioned training program before any purchase can proceed. Yet this isn't a brief administrative form or abbreviated instructional video. It incorporates mandatory live ammunition instruction and must be finished within a specified time frame before buying. If your training certification is too aged, it automatically becomes invalid. That means advanced planning matters substantially more than previously required. Then there is Washington's Extreme Risk Protection Order system currently in place. Law enforcement isn't the sole entity capable of requesting temporary firearm removal from an individual. Relatives, cohabitants, or previous romantic partners may also submit legal petitions. The threshold for approval is minimal. The legal process advances rapidly, and firearms may be confiscated before you ever receive opportunity to respond or contest the action. Combine all these elements together, and the clear pattern emerges. Washington didn't prohibit ownership outright. They simply rendered routine compliance considerably more difficult, errors more probable, and consequences substantially weightier if you reside there. Storage choices, training requirements, timing considerations, and personal relationship conflicts now possess significant legal significance. Remaining thoroughly informed isn't optional any longer. It constitutes an essential part of responsible ownership under Washington's current framework. Section 7. Connecticut. Connecticut, the examination audit system extending backward over 10 years. Connecticut belongs to those states where numerous gun owners assumed that if an issue existed, I would already be aware of it. That presumption is precisely what places people in serious difficulty currently. The statute itself isn't newly enacted legislation. What is genuinely novel is how rigorously the state now pursues enforcement and how extensively backward they're willing to examine records. Connecticut has mandated registration of specific semi-automatic firearms since 2013. For many years, enforcement remained minimal and sporadic. Many individuals registered punctually. Some failed to complete the process. Others believed their particular firearm didn't qualify, depended on outdated guidance from various sources, or simply misinterpreted the complex regulations. For an extended period, nothing adverse occurred. That quiet enforcement interval led numerous owners to incorrectly believe the matter had concluded or been forgotten. That situation is shifting dramatically in 2026. Connecticut is initiating comprehensive examination of all registered firearms. And this isn't elementary paperwork review or casual verification. Authorities are systematically cross-referencing registration records against purchase histories and background verification data. If a firearm should have been registered yet wasn't, the state already possesses sufficient information to identify and flag it. This isn't speculation or guesswork. Dealers submitted purchase documentation. Background checks were officially recorded. The paper trail exists if authorities determine a firearm was never properly registered. Possession alone can trigger substantial penalties, including significant incarceration and substantial monetary penalties. And it doesn't matter whatsoever that the acquisition occurred over 10 years ago. Passage of time doesn't eliminate the legal requirement. Additionally, safekeeping regulations are tightening further. In April 2026, any registered firearm must be properly secured when not in active use. Failure to comply is treated as an independent criminal violation. That means even someone who satisfied every other requirement can still face prosecution over storage compliance. If authorities determine the arrangement wasn't compliant, here is the genuine concern for owners. Connecticut isn't publicizing this enforcement push through headlines or postal correspondence. No reminders exist. No grace period is offered, no built-in second opportunities provided. If you reside there and possess a firearm falling under these regulations, verifying your current status falls entirely upon you personally. That means examining registration records, confirming safekeeping compliance, and maintaining proper documentation in Connecticut. Remaining silent and hoping for favorable outcomes is no longer a secure approach for anyone. Section 6. California. The merchant sales prohibition constricting an already limited system further. California, gun owners have grown accustomed to stringent regulations over decades. Extended delays, restricted selections, extensive checklists for every transaction. So when authorities announce another modification, many dismiss it assuming it won't impact their current possessions. That is where serious difficulties originate for unprepared owners. Beginning July 1st, 2026, California introduces a fresh restriction specifically targeting what licensed merchants may legally sell. Under this new statute, merchants are forbidden from selling specific semi-automatic pistols that authorities believe can be altered to discharge automatically without replacing substantial internal components. That might sound like a limited category, but the official definition is expansively broad, and the authority to determine what qualifies rests solely with the Attorney General's office. Here is why that matters significantly for buyers. The Attorney General will publish an official catalog of pistols falling under this regulation. Once a model appears on that catalog, merchants can no longer legally sell it in California. No exemptions are granted. No alternatives exist, and merchants disregarding the catalog face substantial monetary penalties and potential criminal exposure. For gun owners, this signifies the already restricted selection of handguns available for purchase is about to shrink further. Models that were legally purchasable one day may completely vanish from shelves the following day, based entirely upon how authorities interpret this vague standard. If you already possess one of these pistols, authorities aren't forcing you to surrender it. California's existing grandfather provisions still technically apply, but your future options become severely restricted. You cannot sell that firearm to another California resident. You cannot transfer it within the state boundaries. Your only legal avenues are out-of-state transfer through a properly licensed dealer or surrendering it to law enforcement. Timing becomes absolutely critical here. If you're considering selling a firearm that might appear on this catalog, delaying too long can eliminate every option. Once the July 1st deadline arrives and a model is officially listed, the opportunity closes permanently. What renders this particularly hazardous is how quiet the process can be. No personal notification arrives when a firearm joins the catalog. The burden falls entirely upon the owner to monitor updates and comprehend how they apply in California. Remaining legal isn't merely about what you possess, it involves constantly watching the catalogs, knowing the specific dates, and acting before options completely vanish. Section 5. Maryland. The 90-day countdown following the fresh prohibition catalog release. Maryland's system operates fundamentally differently from most states, and that distinction is where numerous individuals stumble and fall into violation. Rather than concentrating on specific features or configurations, Maryland prohibits firearms by official designation if a specific make or model appears on the state's catalog. Possession alone becomes unlawful, regardless of other factors. It doesn't matter how it's configured, it doesn't matter how responsibly it's stored, and it doesn't matter how long you've possessed it. In 2026, that catalog is expanding significantly. Authorities have announced an expansion adding dozens of additional firearms, many being newer models that didn't exist when the original prohibition was passed years ago. Some were engineered specifically to satisfy older regulations that existed. Others were sold legally for years without any complication. Once the updated catalog is officially published, all that history ceases to matter legally. Here is the portion demanding your complete and immediate attention. When a firearm joins Maryland's prohibited catalog, owners receive exactly a 90-day window to respond. During that period, you may legally transfer the firearm out of state through a licensed dealer or surrender it to law enforcement. After those 90 days completely expire, possession becomes a serious criminal offense with no exceptions. No grandfather protection exists for firearms newly added to the catalog, no registration alternative to retain them, and absolutely no extension if you miss the deadline. Once the window closes, the law treats possession identically to completely disregarding the prohibition entirely. This creates a serious practical problem for owners. When the catalog releases, licensed merchants become overwhelmed with transfer requests. Out-of-state purchasers become more difficult to locate quickly. Appointments fill rapidly. Individuals waiting until the final weeks frequently discover they've exhausted their available time. Another serious concern is awareness. Maryland doesn't dispatch notifications to gun owners when the catalog changes. If you don't actively monitor updates, you may not realize your firearm is affected until the countdown is already well underway. If you reside in Maryland, preparation proves absolutely essential. Know precisely what you possess. Know exactly when the catalog releases, and understand that once the 90-day countdown begins, every single day matters critically in this jurisdiction. Waiting to observe how circumstances develop can cost you far more than you ever anticipated. Section 4. New Jersey. When substantially identical transforms legal firearms into illegal ones overnight, New Jersey doesn't depend on feature inventories the way numerous states do. Instead, it employs specific terminology that sounds innocuous until you witness its actual application, substantially identical. And in 2026, that terminology is performing substantial legal work. Here is how it actually functions in practice. New Jersey prohibits specific firearms by official designation. Then it proceeds further and prohibits anything authorities determine is substantially identical to those designated firearms. That determination isn't restricted to precise matches. It's based upon overall construction, operation, and physical appearance. In straightforward terms, a firearm can be completely legal when you acquire it, remain unchanged in your safe for years, and later be reclassified without you modifying a single component yourself. What is shifting currently is the scope of application. The Attorney General is expanding the catalog of firearms considered substantially identical. Many of these are models that were sold for years as fully compliant. Merchants sold them openly without concern. Purchasers were assured they were acceptable, and for an extended period they were legally fine. The difficulty is that New Jersey doesn't recognize good faith dependence as protection when the catalog changes. Legality changes correspondingly and immediately. No grandfather alternative exists for firearms newly added under this standard. Once a firearm appears on the expanded catalog, possession becomes unlawful immediately. No registration window, no phase-in period, and no warning delivered to your residence. The state's position is straightforward. It is your personal responsibility to remain current with the catalog. The penalties are severe for violations. Possession is treated as felony-level offense, carrying years of potential incarceration exposure and substantial monetary penalties. That is a severe outcome for someone who followed regulations as they understood them at the time of acquisition. What renders this particularly challenging is inherent uncertainty. You cannot examine your firearm and easily determine whether it is about to be reclassified. You cannot depend upon how it was originally marketed, and you cannot depend upon how long you've possessed it without previous complication. If you reside in New Jersey, awareness matters more than comfort. Monitor updates as they're released. Know precisely what you possess and be prepared to respond quickly if circumstances change. If a firearm you possess appears on the expanded catalog in this jurisdiction, legality isn't merely about what resides in your safe. It concerns how authorities choose to define it at any moment. Section 3. New York. Re-registration enforcement funding and the critical June 30th deadline. New York has a tendency of handling matters in a very particular manner. Not conspicuously, not dramatically, but in ways that quietly convert yesterday's full compliance into today's serious problem. And in 2026, that tendency is fully visible and active. Let us begin with the portion most individuals completely overlooked. New York didn't merely maintain its existing regulations in place. The state allocated substantial additional resources toward enforcement. Millions of dollars were designated specifically to pursue assault weapon violations. Additional investigators, additional follow-ups, additional prosecutions. This isn't about enacting a fresh regulation and hoping people voluntarily comply. This involves actively seeking out violations and errors. Now, here is where it becomes genuinely interesting for owners. If you registered a firearm years ago under New York's existing system, you might assume you're completely finished with requirements. Paperwork submitted, box marked, problem resolved. Not any longer. New York is implementing a fresh registration system, and if your firearm was registered under the previous one, you must re-register it by June 30th, 2026. Miss that specific date, and the state treats your previously legal firearm as currently unregistered. That means possession alone can place you in felony territory immediately. No modification to the firearm, no misconduct, simply paperwork that wasn't transferred from one system to another punctually. And no reminders exist, no electronic messages, no letters, no friendly notice stating, "Hey, don't forget the responsibility falls entirely upon you to know this exists and act upon it properly." New York's position is straightforward. If you own it, you're expected to know the regulations even when they shift quietly without announcement. What worsens this situation is the confidence trap. Numerous gun owners did everything correctly originally. When the SAFE Act initially took effect, they registered, they complied, they remained trouble-free for over a decade. That history generates dangerous false security, and that is precisely what this fresh deadline exploits. So here is the critical conclusion. In New York, previous compliance doesn't shield you from future enforcement actions. June 30th isn't merely a date on the calendar, it is a hard boundary. And crossing it without recognizing what changed is how individuals end up explaining themselves in places they never expected to be. This is where ownership ceases being theoretical and begins dictating where you may travel, what you may do, and whether retaining what you possess even remains sensible any longer. Section 2. Rhode Island. The July 1st, 2026 prohibition with severe possession restrictions. Rhode Island is among those states people don't anticipate appearing near the top of a catalog like this. It is small, it is quiet, and for years, numerous gun owners assumed major changes would strike elsewhere first. That assumption is precisely why this law is catching so many people completely unprepared. Commencing July 1st, 2026, Rhode Island implements one of the strictest firearm prohibitions in the entire nation. This isn't a partial regulation or symbolic update. It constitutes a complete prohibition on manufacturing, selling, purchasing, and transferring what the state defines as assault weapons. And the definition is where complications begin for owners. Under this law, any semi-automatic rifle with a detachable magazine is prohibited if it possesses even one listed feature, not two, not a combination of features, just one. That catalog includes items numerous owners already possess: a folding or adjustable stock, a grip positioned beneath the action, a bayonet attachment, a threaded barrel, or similar accessories. The same logic applies to specific semi-automatic shotguns based upon stock style or magazine capacity. The penalties aren't theoretical possibilities. Possession can bring felony charges, serious incarceration exposure, and monetary penalties that follow you long after the case concludes. This isn't a technical violation that gets dismissed or ignored. It is the type of conviction that affects voting rights, employment opportunities, housing applications, and future firearm ownership permanently. Yes, Rhode Island included grandfathering, but it carries restrictions so tight that numerous owners don't recognize the situation until they examine examine the fine details carefully. If you already possess a firearm before the deadline, you may retain it, but only in very limited locations: your residence, your business premises, property. You personally own a licensed range, and transportation between those locations must be direct and secure. That is absolutely all. You cannot take it onto public property. You cannot loan it to an acquaintance. You cannot sell it to another Rhode Island resident. You cannot transfer it to your children if they reside in the state. Even lawful inheritance becomes problematic unless it involves out-of-state transfer. There is another important detail people overlook. If you relocate into Rhode Island after July 1st, 2026, you cannot bring these firearms with you at all. Even if they would have been permitted under grandfather provisions for current residents, they become unlawful the moment you cross the state border. So, what does this signify in practical terms? If you reside in Rhode Island, you must know precisely what you possess, how it is configured, and where you are legally permitted to possess it after the deadline. You must also determine whether those restrictions are something you can tolerate long-term. For numerous owners, the safest options occur before July 1st. Out-of-state transfers sales while the window remains open. Planning ahead, rather than reacting under pressure in Rhode Island, waiting until the law takes effect doesn't reduce risk. It substantially multiplies it. Section 1. Massachusetts. The imitation rule that places even compliant builds at serious risk. Massachusetts occupies the top position of this catalog for one specific reason. It is the jurisdiction where doing everything correctly according to official guidance still proves insufficient for protection. People follow regulations carefully. They consulted knowledgeable merchants, they acquired firearms that were sold as fully compliant, and years later, they are discovering that none of that guarantees legal protection any longer. Massachusetts law doesn't merely prohibit firearms by features or by official designation. It proceeds further. If authorities determine a firearm is a copy or duplicate of a prohibited model, possession alone can be treated as serious criminal offense, and the individual making that determination isn't a court or jury. It is the Attorney General personally. Here is where circumstances become genuinely hazardous for owners. For years, manufacturers sold rifles that were modified to satisfy Massachusetts requirements. Specific external features were removed, configurations were adjusted. Licensed merchants sold them openly without concern. Purchasers departed believing they were legally secure. Now, the state's position is that many of those firearms were never lawful to begin with. The standard being applied isn't about what components are physically attached. It concerns how the firearm operates mechanically, how it is fundamentally engineered, and what it resembles in function. If authorities determine it functions like a prohibited model, fires identical ammunition, or shares core engineering, it can be labeled a copy even if it lacks the specific features people were instructed to be concerned about. This isn't hypothetical speculation. Enforcement has already occurred. People have been prosecuted. And Massachusetts law carries mandatory minimum sentences. That means judges lack discretion in sentencing. A first offense can mean genuine incarceration time. A second offense elevates that minimum floor even higher. What renders this particularly difficult to manage is timing uncertainty. No single deadline is circled on the calendar. No official announcement states your firearm is now unlawful. The risk emerges through interpretation and enforcement actions, not from a clear commencement date. That leaves owners constantly speculating, and speculating incorrectly can cost everything they possess. Another serious problem is broken trust. Numerous individuals depended upon what merchants told them at the time of acquisition. Others depended upon older guidance that no longer reflects how the law is being enforced in Massachusetts currently. That good faith dependence doesn't protect you legally. The responsibility falls entirely upon the owner personally. If you reside in Massachusetts and possess a rifle that was sold as compliant, the wisest move is obtaining professional clarity before someone else makes the determination for you. That means professional legal counsel, not informal forum discussions or outdated assumptions. It means reviewing precisely what you possess and understanding how the state currently views it. Massachusetts doesn't wait for errors to occur conspicuously. It waits quietly And for gun owners who assumed compliance meant security, that silence has already proven extremely expensive. I recognize this was considerable information to absorb and process. None of these statutes are simple, and none are forgiving if you err in compliance. But the objective here wasn't to overwhelm you unnecessarily. It was ensuring you aren't caught unprepared by changes already in motion. These regulations are being enforced whether people approve or not, and the distinction between remaining secure and facing serious consequences frequently comes down to knowing precisely where the boundaries are before you cross them. If this analysis helped you comprehend what is occurring and where the genuine risks actually lie, make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.